Good morning, everyone, and thank you so much for joining us for our monthly mediation forum. As you all have already heard, my name is Rebecca Taylor, and I'm the moderator for this forum today for the ADR section, Alternative Dispute Resolution. If you are not a member of this section, I encourage you to join this dynamic group. Our membership is comprised of mediators, arbitrators, and attorneys who participate in various forms of dispute resolution. The ADR section offers valuable resources and networking opportunities with others who are leaders in the field of ADR. As to the housekeeping matters, if you wish to ask questions of the speaker and need any technical assistance, please utilize the chat. The presenter will answer all questions at the end of the program, or however you would like to do it, Gary. This program is being recorded and can be viewed at a later date on the ADR Section's YouTube channel, as you've already heard. You will need to log in to the Florida Bar Members Portal to enter your own CLE credit. The course number for the CLE today is 9314. Again, 9314. And it will be 1 hour of general CLE credit, which can be used toward 1 hour of tech credit as well. This credit also qualifies for CME, which does not require a course number, as it is self-reporting for the purpose of renewal of mediator certification with the DRC. Now I'm going to turn it over to my amazing business partner, Alicia Perez, and she's going to introduce our wonderful speaker and annual sponsor of ADR Notable, Gary, this morning.
Good morning, everyone. All right, I'll make this short and sweet because there is so much to say about Gary, but I will keep it very short. So, Gary graduated from the University of Chicago School of Law and has been practicing and has over 40 years of experience in private practice. He was an in-house attorney and general counsel and entrepreneur in successful technology startup companies. And that legal experience convinced him of the benefits of ADR and inspired him to apply those same skills to the development of technology for dispute resolution practitioners. He is the founder of ADR Notable, a case and practice management software designed specifically for ADR practitioners, co-chair of the technology committee of the ABA dispute resolution section, and a frequent speaker on ADR technology. The program itself is great. Rebecca and I use it, but there's so much more to say to that. So thank you so much for being here, Gary, and we are turning it over to you.
Well, thanks so much. I appreciate the opportunity to talk to your group this morning. And I really appreciated the partnership we've had with the Florida Bar Alternative Dispute Resolution section. So what we're going to do today, I hope, is going to be fun and interesting. And I will tell you right now, it's a little bit out there. There is no one actually doing what I'm going to show you today yet. So this is a sort of a glimpse, I hope, into the future of things. But what we're going to talk about specifically is how you might be able to use a large language model chatbot to help prepare parties or counsel, but we're going to focus on parties, prior to a mediation. And we're going to, kind of step back for a minute and talk about why that might be important. Well, here, let me change slides here. This is the meeting program, went too fast. Back one. So we're going to talk about, the importance of prior preparation and then give you a sense of sort of the topics that, and this will be probably a refresher for many of you who are experienced mediators, but some of the topics you might address during mediation preparation. We're going to talk about how that's typically done today. And then we're going to introduce this idea of how a large language model like a chatbot could be used for mediation preparation. We're going to talk a little bit about the issues that you may be aware of around using a chatbot, and then we're going to do a live demo where I'm going to use a particular chatbot. I'll introduce in full voice mode, and I'm going to role play a party. And you're going to listen to the participant to how the chatbot would help that party get ready. So here we go. Starting with the importance of prior preparation, and I confess that this sort of seems intuitive to me, but I have been a big advocate or a big fan of work by Professor John Landy of the University of Missouri School of Law. And he talks a lot about this in the academic work that he has done for many years. And basically, you just want, I think, in the prior preparation, you want the parties to be, first of all, prepared for the environment. So they're comfortable, their minds are not focused on a million distractions, but they have kind of gotten ready for what this is going to look like, who's going to be in the room, and what the objectives of the day are. And obviously, you would want to emphasize concerns about confidentiality. And in a perfect world, a conversation may have occurred with a party in advance to help them kind of organize their own thoughts. You might put it in the language that we're all familiar with of having them help identify or helping them identify their own BATNA, their best alternative to a negotiated agreement. You might spend some time helping them think about the other side's perspective. Um, and understanding maybe a little more clearly what their real objectives are. And this may be, as we'll talk about, a discussion of the differences between positions and interests, and getting them really to focus on what practical outcomes might look like. And maybe the most important is, putting them in a mindset which you can tell them, look, this is temporary. We're going to try this. If it doesn't work, okay, you can go on with whatever the alternatives are, litigation or whatever. But for the next, for this day or however long this may take, we're going to really try to find middle ground, and you try and get them in that mindset. And there's actually, the reason you would do this is that the benefits of thorough preparation has been really actually supported by empirical research, that it actually statistically increases the likelihood of reaching an agreement if the parties have been given some prior preparation, and they report in surveys higher satisfaction level with the process, whether or not they actually reach an agreement. And it usually helps also sort of maybe address some of the emotional components, and may make the whole process just a little bit smoother and a little better understood prior to stepping into the room. And the basis of this is research done here by Roselle Whistler, which was provided to me, frankly, by RSI, for those of you who may know that organization. Resolution Systems Institute is a think tank in the field of mediation, and particularly court mediation, that's based in Illinois. And I was working with them, and they were able to identify this research for me. And I will say that the quote on the slide is a kind of a side finding, to be perfectly honest. The actual research was on what happens, or whether having counsel participate in a mediation is helpful or harmful. But as a part of that, in the questions they asked, one of the questions was whether the counsel had provided the party with prior guidance and preparation. And so this was a statistically significant sort of ancillary finding to the research. And it of course, it follows, I think, what you would logically think, right? If you have the time and the capability to spend with the parties prior to the session itself, you're much more likely to put them in a mindset for success of the mediation process. Okay, so what does this look like in practice? And basically, it does. Most preparation goes through everything from the basics of what to wear and who will be in the room, to really getting into some of the elements of negotiation theory. So, maybe the most important starting point is just to explain what the process looks like and what the roles are for everybody who may be in the room. You want to talk about your own role as a neutral, and that you're not supposed to be providing legal advice, but you are kind of responsible for the process and helping the parties move forward, listening carefully for common ground, identifying it, bringing it forward. And to some extent, maybe helping them identify all of the issues they really need to resolve in order for this to be a stable and long-lasting outcome and agreement at the end. Obviously, talking about the roles of the parties and emphasizing that they are ultimately responsible for the outcome, that nothing can happen here without the collaboration and ultimate agreement of the parties who are in the room, and that they're really in charge in that sense, and that they are empowered during the process of mediation to determine their own future. So that's important. And I think, some guidance is often given about how they might actively participate in a useful way. And this goes back to what I said a minute ago about having identified previously their interests as opposed to their positions, and having some expectation for compromise and some openness to listening to the other side prior to going into the mediation. And then last is the roles of counsel. And if counsel is present, and they're obviously not always true, you would want to talk about that the role of counsel is kind of your aid as a party to help you answer technical legal questions and maybe evaluate your alternatives if a matter is not resolved through mediation. And Professor Landy has this the LIRA, the litigation interest and risk assessment, program or process that he talks a lot about, which is just an organized way to go through kind of a look at the risks at the risk assessment for in the event that mediation does not succeed. Again, some of the other things that you might want to think about, as I mentioned a couple times now, is clarifying the difference between interests and positions, and addressing the emotions. And I think every mediator I've ever spoken to who does a lot of hearing preparation talks about that preparation step seems to often take a lot of the drama out of the ultimate meeting. It's a way to vent. It's a way to feel like they're being heard, and it's a good way to kind of de-escalate things before they're in the room with the opposing party. So that may be an important outlet that is useful in this step. And preparing to manage emotions. I mean, you don't want to try and tell someone that they need to pack their emotions in a little box and ignore them. That's not necessarily helpful to the ultimate outcome. But you do want them, you want to acknowledge their emotions, and that their feelings may certainly have legitimacy, but they need to be able to manage them in a manner that allows them to listen to the other side proactively and potentially reach a compromise. But getting that emotions issue out on the table is often very, very useful. Maybe as important as that is just making sure they're actually prepared to go into mediation in terms of having facts and information marshaled and at their fingertips. The great, an obvious example of this, we've worked with some of our mediators who do mortgage foreclosure mediation. And that one is really getting the facts and the information and the financial position of the party to organized together and frankly shared with the bank or with the mortgage holder is really important, because many banks have programs to do mortgage assistance, and they need the information to understand whether the particular debtor complies or fits into the requirements of their programs. And very often, if there isn't adequate preparation, parties are all called together and nobody has enough information to make a decision to move forward. And you end up having to at a minimum schedule a second session, simply because the first session is spent identifying the information that's necessary to move to the next stage. So you can improve the efficiency of the whole process by addressing those sorts of things in a preliminary meeting. And then last, you want to talk about helping a party think through alternatives. and maybe improving their communication skills. And then a third set of elements here is just really pushing against, the reality boundaries. What's possible, setting expectations for what the communications might lead to, emphasizing a need to, to be civil during the process, and again, those emotions acknowledged but kept in a manageable context, manageable format. And this is an opportunity during preparation to discuss settlement ideas. How might I get out of this situation? What are the things that are possible here? And to get, some feedback and some reality testing, and maybe, spur some creativity. This is a time where maybe new issues can actually be put on the table if they are helpful to reaching a settlement of the things that seem to be of critical importance initially. Sometimes when the technique is described as expanding the pie, sometimes when you expand the pie and you bring in other elements, it actually gives you more opportunities to resolve dispute. And this is an opportunity in prep sessions to think through those things, establishing the mindset of compromise and negotiating limitations. And this is really a critical element of this, is getting a party able to understand what facts are relevant and what facts are maybe not relevant, even if they feel important to that party. They need to understand the things that will maybe contribute to reaching a settlement, and those things which may be outside of what really needs to be discussed. I mean, I often kid about, in a family mediation situation, someone saying that, your mother never liked me. Well, that may be a fact and it may be true, but it's probably not something that's going to really be something you can resolve in the process of the mediation. So it's important to try and help that party understand what's going to help, what facts are really relevant and really essential to move forward. And again, making sure that they have access to the necessary documents, and if necessary, that they're bringing them with them to the session. And maybe this is even outside experts. Maybe there's a financial assistance that's needed in a divorce case. And the question can be raised during preparation whether that assistant should be present at the mediation to help the parties understand the financials, positions of each of the parties, and what some of the potential impacts of resolving their financial situation might have in terms of taxes or other key issues. So the goal is to just sit down with a party in advance and try and identify these things, so that really the actual session can be as meaningful and useful as possible. So how is that done today? We obviously work with a lot of mediators, so I get an interesting perspective from a variety of practitioners, from family to major commercial cases to community mediation associations and everything in between. And obviously this practice varies a lot, but in the more typical, if there is a typical version of it, it's done as sort of intake sessions where the mediator meets individually with the party or party and counsel, if the party has counsel, to try and go through some of these things. Many mediators have kind of a checklist, maybe multiple checklists, so that they touch on all of these things. And they may have multiple checklists for different kinds of cases. I do see, it's an interesting question, because I think Florida may be different about this. question in the chat here about whether it's appropriate for the mediator to prepare parties, or is that the lawyer's job? I mean, I think the optimum is to do these prep sessions with parties and counsel together, because you just, the mediator's in charge of that process, and you just don't know whether the lawyers spend that time or not. And if they're in the room, they can challenge anything that the mediator is saying that they disagree with. But it is probably best for the expectations and that prep session to include both parties and counsel, if counsel is if the party has counsel. You would like to think that the counsel ought to be doing this as well, and certainly there are aspects of it which you might turn to counsel and say, now you and your client may want to spend some time really thinking through this, and just make it a kind of a homework assignment that is that both of them hear, and you can have some reason to believe they actually go off and do. And I know, this is, I think there may be some ethical rules in Florida which are in some states. Let me just put it that way. I think it was Florida that make this, that limit this to some extent. But in most of the 50 states, and certainly in Canada, where we're active, there are really no limitations on this, and it isn't. It is really a best practice to try and get the parties in a mindset ready to do this session, when the schedule permits. And of course, there can always be written materials to help inform and prepare things. Just a kind of a checklist of, this is what the process looks like, and reaffirming that it's confidential, and the parties agree to keep it confidential, and so forth. Many mediators use that as an introductory piece, a part of their actual intake, and it may be appropriate to reiterate it just before an actual session. Now, the reality hits. The reality is that things like court-ordered mediation or a lot of community mediation associations, it's just very difficult to get the time and the resources to do this kind of in-depth preparation that the research suggests is helpful. So, it takes an additional commitment of time to meet with each party individually and their counsel if appropriate. And it increases the costs because your time is not free, the counsel's time is not free. So it does impose an additional cost burden potentially on the parties as well. Often in court-ordered or community mediation, there just aren't enough resources to do this. And I think often, from what we hear, the staff members get bombarded with sort of a number of relatively straightforward and simple questions, with really practical stuff about, how long will this take? Who will be there? Is it confidential? What do I wear? All of that kind of stuff. And maybe they get somewhat dragged into answering questions more about the process, as well as people who are unrepresented and have never been through this before need that help, need that guidance, and need that, frankly, hand-holding a little bit to feel better about the process. And the alternative is, I think as we see, is people show up and you end up spending the first hour of maybe a 4-hour block doing this prep, doing what you could have done in advance. And it is not necessarily making that 4-hour block productive. Often these are volunteer mediators in these contexts, when you're imposing a burden on them, asking them to devote even more time to court-ordered or community mediation processes to really tackle this job in this very thorough way. And then there's the issue of sort of consistency. Now maybe consistency isn't essential here. Maybe every mediator has their own kind of script for these sorts of things. And frankly, I think the research didn't go into depth in terms of what exactly was covered in the prep sessions. It just appeared as though having a prep session, or at least parties who reported having a prep session with their counsel, also statistically showed a more likelihood of resolving the case and a better satisfaction with the outcome. So consistency, there's probably some basics we could all agree on ought to be covered, but consistency is at the moment somewhat left to counsel, and maybe there is some benefit in trying to facilitate a fundamental set of preparatory steps. So what does this leave us? This leaves us with, some way to provide what I describe as scalable and efficient preparation support. How can we let mediation and its benefits grow and expand, and also provide this additional level of service of a good preparation by the parties, so that we do increase the effectiveness, the satisfaction level of the process. I mean, I think this is something we all want, right? We all would like to see the use of alternatives to litigation expand. And I'm between arbitration and mediation, I am a much bigger fan of mediation. I think it achieves a lot of sort of side social benefits for parties who will go through the process and understand they can resolve disputes in a manner other than having a third party mandate an outcome. They can control their own destiny, and maybe they can learn some skills on how to deal with the next conflict that arises in their life. So I'm a much bigger fan of mediation, and if we want to see it grow, and we want to see it be successful, my thought was, what do we do to try and make this prep session concept, which we think is useful, more scalable. And it's a resource constraint, and the consistency and the access to the support is just difficult to provide in a cost-effective manner. So what's one answer to this? One answer that I'd like to introduce, and as I said at the outset, I don't know that anybody is actually doing this yet. So this is kind of a glimpse into the potential future of how we might address this need. And the idea is to use these chatbots, which we can hardly avoid reading about every day. And it's referred to as a large language model chatbot. And I think we all know a little bit about them, but I'm going to go into the background a little so that we all understand what we're talking about. So this artificial intelligence, large language model chatbot is essentially computer systems that have been trained on access to enormous volumes of data, data in this case just being communications, things from the internet, typically pretty much like everything from the internet, from books to recordings to movies to podcasts and to chats. And it's, frankly, they were trained on the good, the bad, and the ugly, the true, the untrue, things that are socially unacceptable in civil society, as well as things that are, intellectually rigorous. So it was just this giant, funnel of things. And the initial intent was just to train these devices to be able to respond in a context appropriate language basis. And then as they got better and better, because they have access to so much actual information and began to be able to contextualize it, they become an amazing, really a fascinating resource. And they are capable of relevant context specific interactive conversations. Now, one of the things to think about here is what, as I mentioned, these things were trained on the good, the bad, the ugly, the true, the untrue, things that were socially unacceptable, but are obviously available on the internet. And then backing away from the early versions of these things that were sexist and racist and just could spurt out some pretty awful stuff. the people running these chatbots have progressively put programming in to filter out the worst of the worst, and they've gotten better and better and better at this. Now, this has achieved a couple things. One is they're much more socially appropriate and accessible. It also has achieved a few things like that they tend to be a bit too agreeable. They won't challenge you. They won't push you a little bit. They kind of agree with everything you say to make you feel good about yourself and engage in the chat. So there's some downsides here. They do still hallucinate, is the word they've been given for when they just seem to make something up that and no and even the people who are building the chatbots don't fully understand why or how they do this. The methodology of chatbots is this sort of crazy analysis of probability of what word follows the prior word by looking at an enormous database. If I'm talking about seeing a large school and something in the context says I'm on a boat, the system actually associates that school with school of fish, not school of building, because it looks in its database and says, no, it doesn't make sense for somebody who's out on a body of water to see a school in the sense of a school building, but it does make sense to have it be a school of fish. So it's doing this on just literally enormously grinding away probability statistics of what was intended. And every now and then, these systems take flights of fancy and create connections that we don't understand and are not correct. One solution or one mitigation, I won't call it a solution because it's not perfect, but one mitigation to that is instead of using the basic publicly available chatbot like ChatGPT or any of the non-commercial ones, Gemini from Google and Claude from Anthropic, is you can create your own large language model. And what this is doing is it's taking the skill set of how to do this linguistic gymnastics and speak to you that it learned from the huge database, but now you give it a more refined, more specific database and say, okay, system, answer questions that I put to you out of this data as your primary source. And when you do that, and you compel the system by programming to answer your questions out of a curated, selected database, you significantly improve the responses in terms of relevance, and you decrease the number of these crazy flights of fancy that make up things that you can't understand where it's getting the answers from. So what we're going to talk about here is a custom trained database and a whole series of internal prompts or programming that helps improve the relevance and accuracy of the responses of the data. And as I mentioned, I'm a big fan of Professor John Landes, and he's working, early on, he and I worked together looking at his scholarship. He's been a very active publisher over his many years of as an academic in the field. And I really was drawn to it. It's a very, I commend you to it. It is a very practical approach to how to operate a mediation process that starts with a lot more preparation than as I think people think of normally. He used to take on the his fellow academics who talked a lot about facilitative versus evaluative and all of that, saying, listen, the good mediators employ those processes and weave in and out of them as they perceive the parties need them to do that. And he kind of went after his own colleagues in the academic world to sort of say the reality of this is very different, and they need good mediators need a whole set of skills, and they need the judgment and the preparation to understand how to employ those skills, each of those skills as needed and when needed. No, so he and I worked together and he actually created some very useful checklist approach to preparation ahead of things which we published in ADR Notable or available to any ADR Notable user for free. But then John took another step and a little bit of prompting from Susan Guthrie, as many of you know, very strong advocate for the use of technology in our field. He created his own curated database inside ChatGPT, which he calls his academic theory is called real practice systems. That's this whole concept of what's the reality of how you need to really do their job and how can we make them better at it, and giving people some tools to be more consistent, more thoughtful. So the real practice systems and the whole thing is called the real practice systems mediation and negotiation coach. And what he did was take his life's work and put it into a separate trained database within ChatGPT, and then wrote system prompts to force the system to first try and answer any question that he presents it out of his own academic work. And then he added some very carefully curated components to it, so that you now have a database that is uniquely designed for mediators, with content that has been carefully selected so that you don't have some of the crazy or horrible, in some cases horrible things that are in the publicly the full public training databases. So what this does when you curate a training database is as the slide suggests, it enhances the accuracy and reliability, and it minimizes the hallucinations. And he has made this available for free. If you just Google RPS Coach ChatGPT or something like that, you'll get a link to ChatGPT. It is available in the free version of ChatGPT, and I would highly recommend you try that out at some point. We're going to see what it does here in just a few minutes. So the idea that I've now kind of put together here, where really it's John's idea, is that you can use an AI coach that is really just looking at the science, the art and science of dispute resolution, and make it accessible to parties or to counsel or both. As well as being a coach for you as a mediator, it can be a coach for the parties. And maybe, just maybe, this works to answer this problem of the scalability of this kind of preparatory work. It would free sort of the court staff certainly, and maybe community mediation staff from answering basic questions, and may be able to help the parties actually prepare in some depth. So they're accessible, online, anytime, anywhere, 24 hours a day, 7 days a week, and they speak multiple languages. So you now have this tool, which, as I said, we'll demonstrate here in just a few minutes, that would help talk to people, and honestly, one of the craziest things about these systems is they can be empathetic. They can speak to people in a very calm, very helpful, almost you would have to say, I put with air quotes, understanding sort of way. And be very useful, very helpful. Consistency of guidance would be useful, and obviously at the moment it's free, and so it's cost effective. Okay, but as we all know, there's lots of concerns about chatbot accuracy and security. So I want to make sure that before we jump to the next thing, that we talk about that. So when you use your own training database, you can set the rules. So John has set the rules in his so that your prompts do not go into the training database. Now, your dialogue with the chatbot is still maintained in your account in ChatGPT. So let's just be clear, things you put in that it's kind of like writing it out in a document and storing it on your computer. It's not any more susceptible to hacking than something like that, but it is somewhat susceptible to hacking. So, it is a record and it's stored. It has a lot of security around it, but no security is absolutely bulletproof. So you do want to keep that in mind. But it is also, it's going to give them good information because it is in this curated database. It's going to give them really helpful, relevant, trustworthy advice because it's not looking to the world as at large or to the entire training database of ChatGPT, but a limited one for purpose, built for purpose. I kind of jumped ahead of myself here. Do need to address the privacy and confidentiality of the use of an LLM. Generally speaking, you want to avoid putting very sensitive information into it, but you can safely encourage people to have conversations with this in my judgment. And a lot of people would argue with me about this, but I've spent a lot of time looking into the security of these systems. And the most likely problem is that the user is clumsy or uses poor password management, and that they get their system hacked through their own somewhat negligence. That is by far the most likely way this could become. There could be a breach or unauthorized access. Hacking into ChatGPT from the outside otherwise is unbelievably difficult, far more difficult than it would be worth for anybody to do to go get one particular chat. I mean, if they're going to do that, they're going to try and penetrate ChatGPT security completely, in which case you'd be getting a lot of information that would be much more valuable probably than any one chat. So it's not, it's not risk-free. I'm not going to try and tell anybody that, but it is no more risky than somebody writing down their thoughts, their personal views on a document and storing it somewhere on their computer or in the cloud. I think if you were to do this, you would have to, there would certainly be some practical and ethical considerations. Clear disclosure, right? You would have to make sure everybody knows you're talking to a chatbot. And you might have to talk to them about some of the security and what happens to it. They can, of course, also change their own security settings as they do this in an account in ChatGPT. And they can have their chats deleted, for instance. So clearly those are, ideas that are, useful to express right up front. I think there is also some research that suggests that people will ask questions of machines or robots or however you want to judge, describe them, that they actually may not ask of you. Because no matter how hard you try to be non-judgmental and express that, you're still another human being. And the perspective is, and there's a lot of research in the medical field about getting prior medical histories, that people are more open and more honest when they think they are talking to, when they know they're talking to a device or a robot, than they are when someone is sitting across from them taking down the notes of their prior history. So there may be some utility, some kind of odd utility to using a chatbot in getting them really to express themselves more fully. You do have to make sure that the system does not engage in the unauthorized practice of law. John's done a pretty good job of building the prompts to avoid that. And I think you can always want to kind of do some, any one of these tools would have to be backstopped by periodic human testing, where, somebody not really a party goes in and uses the tool and sees what it can do and sees what it's saying and so forth. So you would want to preserve that. One other practical thing that I thought of that I didn't put on the slide that I do want to acknowledge is that a lot of practitioners actually use these kinds of preparation sessions to build rapport and confidence and trust with the parties. And obviously, if you're going to use a chatbot to do this, you are foregoing that opportunity to have one-on-one dialogue and build that kind of rapport and kind of do a see for yourself where this person is emotionally and about the issue. So this is an opportunity to use it where to get the preparation done where there may not otherwise be the resources to get it done. Okay, so here we go. This is the exciting part of I'm about to try and do a live demonstration here. And I started out my practice of law as a litigator, and I remember vividly being told in a CLE session never to do live demonstrations in court because you just can't control them all the time. So I am now violating egregiously the advice I received as a young lawyer, and we're going to try and do an interactive live demo of this. So here's the story. That's a storyline I've set up. I'm going to do a little role play. I am going to play the role of Pat Taylor, a late 50s employee of a large retail chain. He's been with the company a long time, has done very well there, and he's now a manager in the customer service department. He's gotten a new VP, the new vice president has started pressuring him to do more with less. Great phrase we hear a lot of these days. And he's supposed to do more with less and still maintain both customer satisfaction and staff morale, which is obviously, as we all know, are goals very dramatically in tension with one another. So, he's doing his best. After some conflict, he's actually been put on a PIP, a performance improvement plan, which he just finds, given where he is in his life and his loyalty to the company, to be grossly unfair. He's gone to HR, and HR has suggested that they have a kind of a mediation session with his VP. So here's what we're going to do. I'm going to introduce you to our coach. I got to tell you, because it's a lot of fun, that the picture of the woman on the left is a completely artificial intelligence generated picture. That woman does not exist anywhere. Pat on the right is an image I pulled down off of one of the commercial image systems called iStock. I don't know whether there really is a guy who looks like that or not, or if it's AI generated as well, but his image is available for commercial purchase, so I'm feeling okay about that. And now I'm going to bring in let's see if I can put this on your screen. It's not a very pretty picture, but here we go. And I'm going to play the role of Pat, and we're just going to listen to, let me back up and tell you what I've done here. So I have a commercial version of ChatGPT, which allows me to do full voice response. So as we talk about this, you're going to hear the response. I'm just going to talk to it. Most systems are still in the chat mode where you have to type out your chat and your ChatGPT. It occurs to me I may have to stop share and reshare here because I need to pick up the screen. So let me do that really quickly. Stop share. And I need the sound. Okay. All right, so here we go. And as I said, I'm going to play the role of Pat, and then you'll listen to the dialogue. Okay, let's see what this thing can do. I'm Pat Taylor, and I'm getting ready for a mediation session with my employer. I've been at the company a long time, and well, things have gotten pretty rocky lately. I haven't done mediation before. I don't have a lawyer, and I'm hoping that you can help me get my head clear. Oh. Okay, here we go. This is why you don't do live demos, right? Okay, well, let's see here. Hey, ChatGPT, are you there? Coach? Okay, let me end it and start it again. Sorry about that. Hey, Coach, are you there?
I'm here, Pat. Go ahead whenever you're ready. I'm listening.
Okay, let's see what you can do. I'm Pat Taylor, and I'm getting ready for a mediation session with my employer. I've been at the company a long time, and things have gotten kind of rocky lately. I haven't done a mediation before, and I don't have a lawyer. I'm hoping you can help me get my head clear.
Absolutely, Pat. I'm glad you're getting ready. This kind of preparation can make a huge difference. Let's start simple. What's been going on at work? When you say things have gotten rocky, what do you mean? And what would you like to see happen through this mediation?
Well, here's the deal. I mean, I've been at this company in customer service for almost 40 years. I'm a manager, and I've always gotten good reviews. But about a year ago, they brought in a new VP in the whole division, and things have been really hard ever since. The expectations have ramped up, and they're just not realistic. They want faster calls and better customer satisfaction, and I'm being told cut staff at the same time. So I just don't know what to do or how to get out of this situation.
Thanks for walking me through that, Pat. That sounds incredibly frustrating, especially after such a long, solid track record. Let's slow it down a little and look at what's most important for you heading into this mediation. First, what do you want out of it? Are you hoping to stay in your job, shift roles, leave with a package, get an apology? What feels most important to you right now?
Well, the first thing is, of course, they put me on this performance improvement plan, which I just found kind of insulting. It's never happened to me in 40 years. I think really what they're trying to do is push me out.
Yeah, I can hear how much that stung. After all that time and steady performance, getting hit with a performance plan out of the blue would feel like a slap in the face. So let me ask, are you hoping to get the plan removed? Or are you leaning toward finding a respectful exit? Or maybe you're still deciding and want to keep your options open for now.
Yeah, I think I'd rather, have basically, I'd like to have things go back the way they were before, where I was a respected employee and I was doing a good job for the company.
That makes a lot of sense. You're not just looking for a technical fix, you want your dignity and your standing in the company restored. So maybe part of your goal in mediation is to be heard and recognized for what you've contributed. Do you think there's any chance they'd be willing to roll back the performance plan or even reframe it in a way that doesn't feel like blame? Or do you feel like they're already locked into a direction you can't influence?
Yeah, honestly, I kind of feel like they're just trying to push me out because I'm older. And of course, my salary's a little bit higher because I've been around so long, but I don't really know.
Yeah, that's a tough spot. And you're naming something a lot of people feel but have a hard time saying out loud. If it feels like they're sidelining you because of age or salary, that's serious. And it also changes how you might want to approach this mediation. Let me ask you this. If it turns out they are trying to push you out, would your priority be negotiating a fair and respectful exit? Or would you rather stand your ground and try to stay, even if it means a fight? Or are you still torn?
I guess I'm still a little torn. I mean, it depends on if they can really offer me some package to exit that allows me to just move into a comfortable retirement. I suppose at some level that's an option, but it's a little about my dignity, as you mentioned a minute ago too, about leaving on good terms.
Right? That makes total sense. You're not just negotiating dollars, you're trying to shape the story of how you leave, if you leave. That matters a lot, especially after 40 years. So maybe part of our prep is helping you think through both tracks. what staying would need to look like for it to feel workable and fair, and what leaving would need to include, financially and emotionally, for you to feel respected. Want to start sketching those out together?
I think that would be helpful, but first, can you just give me a basic sense of what mediation is and what it'll look like?
Absolutely, Pat. Let's take a moment for that. Mediation is a structured conversation where a neutral person, the mediator, helps you and the company talk through the issues and explore options. The mediator won't take sides, won't make a decision, and won't give legal advice, but they will help guide the process, keep things organized, and support respectful dialogue. Sometimes you're all in the same room. Other times, the mediator talks with each side separately in private meetings. You can speak for yourself or write things down, whatever feels more comfortable. The goal isn't to win, but to see if there's a way forward that feels acceptable, maybe even satisfying for everyone. Does that help? Want me to walk through what a typical session might look like, start to finish?
Actually, could you just repeat what you just said, but do it in Spanish this time?
Claro, Pat. Aquí va una versión en español. La mediación es una conversación estructurada en la que una persona neutral, el mediador o la mediadora, ayuda a usted y a la empresa a hablar sobre los problemas y explorar posibles soluciones. Esa persona no toma partido, no decide el resultado y no da asesoría legal, pero sí guía el proceso, mantiene el orden y fomenta un diálogo respetuoso. A veces todas las personas están en la misma sala y otras veces el mediador habla.
Okay, I'm going to end it there, but you get the idea because we only have like 1 minute left. So I just, would be really interested if you have the time and the energy to give me some feedback. I will have here's my email address is up there in the top right. I'd love to know what you think about this idea and whether you can see the practical potential of allowing your parties or parties in counsel access to a tool like this prior to a mediation session. I think it has real potential, particularly for some of the more resource-constrained participants in our field. So with that, I'll stop the share. I do have the link here. Hold on, we'll go back a couple slides to the coach. I can put in there. There is the chatbot coach for everybody to see. And all right, I'm happy to stick around. I know I'm right up against my my hour, but if there are any questions that anybody want to ask, I'm fine with people just unmuting and asking me questions directly if you'd like.
Before you, oh, are there any questions? I see one question in the chat. Do we as mediators get access to the conversation the chat bot had with the client?
You would not unless you get permission of the client and you set it up that way, but you could set it up that way.
Okay, I'm just seeing some accolades there, Gary. So I'm going to go on ahead and just say thank you so much for this excellent presentation and to all of you for participating. I think I would have to ask Megan or Sherry to give us the numbers, but it seems like I'm looking at over 50 participants today, which I think from when I've done it, it's been quite a lot. So that's wonderful. But again, the course number for the CLE today is 9314, and that is for 1 hour of general CLE credit, which can be used toward 1 hour of tech credit as well. Coming up, we do have our free monthly arbitrator forums. These forums take place on the second Tuesdays of every month. We also have our ADR retreat, which is going to be on August 22nd through August 24th in St. Petersburg. And we have a groundbreaking film on September 10th, which is with the voice of the mediation client, where we'll hear from actual parties about their insights on the mediation process. Lastly, on September 12th, we'll have another free CLE available. It's entitled Building a Mediation Practice, One Size Does Not Fit All. So we hope you all will join us. We also invite you to join the ADR section to receive access to more quality CLE courses and the latest news on dispute resolution processes. Thank you for being with us today. And I think we can stop.
Yes, there were over 54 people today. Thank you, Gary. Thank you, ADR Notable, for your support of the ADR section of the Florida Bar. Those of you who do not have an existing infrastructure for your business should definitely try ADR Notable. It combines a lot of features that, people have to use a lot of systems to cobble together. So good luck, everybody. See you at the DRC session later today.
Take care, everybody.